Village of Euclid, the village had adopted a zoning ordinance that zoned a particular piece of land owned by the defendant only for sale to single-family residences. The defendant wanted to sell it for a higher price for factories, but it was not permitted to do so by the zoning. The defendant said that the zoning ordinance was unconstitutional and violated his fundamental liberty on property and liberty as to what to do with one's own property. The court rejected that challenge and said that the city had properly exercised its police power to promote the public good. The other two cases involved the same nuisance. The city of Chicago re-engineered the waterworks in the rivers near Lake Michigan to reverse the flow of the Mississippi River to flush water from Lake Michigan and their garbage down into the Mississippi system. In the first case, St. Louis versus Illinois and the city of Chicago, a downstream city, St. Louis, complained this was causing a nuisance. Typhoid germs were coming down the system. The court said that could be a nuisance if you could prove it, but there really wasn't enough proof. About 100 years later, the same water system was allowing Asian carp to move up the Mississippi River and threaten to go into Lake Michigan and the Great Lakes. Upstream states, like the state of Michigan, sued in nuisance the U.S. Army Corps of Engineers and the city of Chicago, claiming the same waterworks was a nuisance because of the carp. This time, the court found there was a nuisance, but refused to issue an injunction because so many other governmental bodies were operating under the police power that they thought the court's injunction would just get in the way.